Do we need 4 for a quorum or 5?
4. So for the people who recently joined, we're just waiting for one more planning board member, so the board has a quorum. Here's Sarah. Yay.
Yay! Right.
Sarah to the rescue.
Sorry, Julie, did you get my message? I would be late.
Yes, we knew.
Yeah,
Yeah.
we just didn't have anybody else, Sarah, unfortunately. And somewhere I have my agenda, which I can't find. Sorry. Okay. So I'm going to open the meeting of the Town of Carlisle Planning Board on Monday, August 10th, 2026 at 7:11 p.m. Our first item of business is the continued public hearing for site plan review for the Newhouse Wildlife Rescue. Do we need to say anything other than the application has been withdrawn?
So we
Julie?
have a withdrawal request, which I'll screen share for you. Hold on one second. Let me just get it. On the
I'm
right.
sorry, did you do a roll call vote for this meeting? This is Cynthia Soren, sorry. I just didn't.
We don't do a roll call until do we start with a roll call? We don't start with a roll call, do we?
You are all remote.
Or we're supposed to start with a roll call if we're all remote?
That is correct, Madam Chair.
Okay. All right. Well, I guess we vote present, right? So, roll call vote, starting with, I guess it's Chris.
Gegas here.
Great.
So do we make a motion or right? I don't know.
No, I think we just say that you're present, right? Good.
Yep. Okay.
Okay.
Chris Gegas here.
Grady present.
Lennon present.
Smith present.
We haven't done an all remote meeting in quite some time. Okay. You want to screen share the?
Yes, that gave me a minute to find the documents, so I appreciate pause. So here is the official withdrawal request from Farrell and Robbins on behalf of Newhouse Wildlife Rescue. So you will need to take a vote to close the public hearing and then also a vote to accept the withdrawal without prejudice.
Is there any discussion from the board? Okay, I'll take a motion to close the public hearing.
So moved.
Second.
Okay, roll call vote starting with Chris.
Gegas, aye.
Grady, aye.
Lennon, aye.
Smith, aye.
And I will take a motion to accept the withdrawal of the Newhouse Wildlife Rescue application without prejudice.
So moved.
I'll second.
Roll call vote starting with Chris.
Gegas, aye.
Grady, aye.
Lennon, aye.
Smith, aye.
Okay. I believe Julie, you suggested we move right to the zoning discussion. Oh, no, sorry, to the West Street Conservation Cluster extension of time to record
Yeah.
permit. Is that right?
And so you have the buyers and and you have the seller's attorney and the buyers here on the call. And so I don't know if they want to chime in and kind of explain what this is for. But I also can screen share the extension of time request that was submitted. So it was in your packet. But my understanding is really it's an extension of time for them to record the special permit decision, which you had granted them an extension of time a couple of years ago to do that. They had recorded the plans, but not the decision at that time.
Okay, so it seems like it was an oversight that they recorded the plans but not the decision, and this is just cleaning that up. Is that the way you see it?
Am I able to chime in here?
Sure.
I'm the attorney for the current owners. It's even a little more simpler than that. The plans got recorded, but the special permit didn't get recorded because the owners had requested that we, they wanted to hold off on that while they waited to see if the town was going to adopt the MBTA Communities Act. And so they might have gone in a different direction. But then there was kind of an oversight and the special permit didn't get recorded. However, the planning board had granted an extension to record the special permit by October 31st, 2024. What we know by the statute that the state enacted, which was Chapter 238 of the Acts of 2024, is that the special permit was automatically extended for 2 years. And what we had asserted and town council had reviewed and agreed is that likewise the recording period for the special permit was extended to 2 years as well, to October 31st, 2026. What we're looking for here is just the planning board's confirmation by way of this endorsement to avoid any title problems. We've already had a buyer's attorney raise the issue and that was after consulting with the title insurance company. And we don't want to have a problem when we go to actually record it with the registry of deed officials, because when you look at the special permit on its face, it just says, with the initial extension to record by October 31st, 2024. We want to remove any ambiguity by including this confirmation called the planning board endorsement that says this is what the law really is. This thing is already extended. And maybe Ethan can confirm that. I don't know.
I'm able to confirm that what you see on your screen, referring to a statutory extension extended by Chapter 238 of the Acts of 2024, is exactly that, one of a series of permit extension acts that have passed through the legislature over the last couple of years. Following COVID, there's been a lot of moving deadlines as a result of this sort of thing. And so all you're being asked to do is to confirm that, the permit holder in this case has the ability to record their decision until the end of October of this year, which is the effect of the law in any event. And so as Attorney Clough has suggested, it's really just to make sure that there's no complications either with the staff at the Registry of Deeds or with the buyers that they're working with, so that there's no cloud on title.
So what you're effectively saying, Ethan, is that the Permit Extension Act extends our extension to the recording of the permit, while
Right.
also simultaneously extending the permit.
Right. So it has the effect of extending any permits like valid and in existence at the time of the act by 2 years. And because this permit has a deadline in it for recording the decision itself, that thing
That is
you
a
have to do.
thing that gets extended to. Got it. So the outcome is more straightforward, but the explanation is more complicated than what I originally articulated. Does any questions from the board on this?
No, I trust that Julie, Ethan sort of helped draft this language, and or you knew what you were doing and no
I-
concerns.
I did have one procedural question, since there are only 4 members and special permits are usually require more than a simple majority. Is 4 members of my board satisfactory for this vote and signing this document?
Julie, it would be my position that, that is sufficient. This is not a vote to grant a special permit. This isn't even, in fact, a vote to extend a special permit. This is a vote acknowledging the effect of, an act of the legislature. That's my perspective on this. But, if the attorney has a different concern or would prefer to wait for, a vote with a supermajority of the board, I wouldn't be opposed to that.
No, I'm
You're muted.
I muted.
Paul.
Paul, you were muted there for the last few bits of what you said somehow.
I'm disagreeing with Ethan. I don't think that we have to hold out for another vote.
Okay. Okay, Julie, should I ask if there's any comments from the members of the public, or is this more,
You can, but you don't have to.
are there any members of the public who want to speak on this endorsement? Right, seeing none, I will ask for a motion to endorse or to
Approve the endorsement.
approve the endorsement. Endorse the endorsement
Extension of time.
for the extension of time for the recording of the special permit for 75 West Street. Map 18, lots 5 and 6X.
So moved.
I'll second.
Second.
Okay, roll call vote starting with Chris.
Gegas, aye.
Grady, aye.
Lennon, I.
Aye.
Okay.
So
Uh,
you will all need to come to town hall at some point as soon as you can to sign the document. I'll email you tomorrow to remind you.
Okay.
Thank you.
All right, shall we move on to the zoning discussion?
Yes.
Specifically the changes to 40A that Ethan's here to present to us.
Sure. I'm happy to take that up. I had the pleasure of meeting with the ZBA just last week to talk this through for the first time. What I did then was to just share on the screen a copy of a client advisory that my office had produced, and I'm happy to just talk through what the changes are point by point. I think most of you are aware at this point the governor's fiscal year 2027 budget legislation had a sort of wide assortment of amendments to Chapter 48, the Zoning Act included therein. That bill was signed on July 9th and has an effective date of July 1st, 2026. The effect being that everything that I'm going to share with you, became effective at the beginning of July. And, that was even the case for things that were, pending or otherwise, already being considered. So it's, caught a lot of us, I don't want to say off guard because we sort of knew it was happening, but I don't think anybody expected it to take effect quite as quickly as it did. Just looking for permission to share a document. There we go. And so I think this might be the easiest way. I'll just put this on the screen. Everybody can see this.
Yeah.
As I scroll through it too quickly to read, I'll make sure it's at a reasonable size. So the variety of amendments, I'm just going to talk through them in order and feel free to stop me if you have any questions. There were amendments done to sections 5 and 11, specifically relating to notice. There's a number, you know what, I did this last time, and it's just going to be better if I show you the red line text to avoid confusion. So apologies here. Section 5 and Section 11 require notices to be sent by mail, postage prepaid for a variety of things, including notices of zoning amendments, and reciprocally in Section 11, notices of public hearings. As you can see in the section I'm showing here, the state has inserted in between sent electronically or, and then continues by mail, postage prepaid. It appears that the intent is to simplify a variety of the notice provisions. I'm sure you're all familiar that, when you review special permits or other things that require abutters notices, all the abutters get mail. It's a lot of postage. I think there's a chance that these amendments were geared towards streamlining that process. Of course, I don't think it's quite as simple as that. And I'd like to think that someday we'll be able to take advantage of electronic notice, but I don't think we're quite there yet. I'll show you in section 11, sort of why that's the case. So again, we decided that, in cases where notice to individuals or specific boards or other agencies required, notice shall be sent electronically or by mail, postage prepaid. But it has to go to parties in interest, and we define parties in interest as being, abutters, owners of land. Unfortunately, as they appear on the most recent applicable tax list, your tax list doesn't have electronic communication information for, individuals. And so, if we were in the process of maintaining, reliable databases that could provide for electronic service, maybe there's a way we could get there so that, we're not sending out hundreds of postcards to alert folks that hearings are happening. But I think we're some ways away. Where this may help is that there are, a number of agencies. So, planning boards for adjacent towns, state agencies that are required to get notice. I think if you have a good email address for them, eohlc@mass.gov, that you can send them information and they're going to get it. And so I think there are a couple of things where notice could happen electronically, but otherwise, I think we're going to have to wait and see how the usage of this develops and, if there's more guidance in the future in terms of what that could mean. So that's in sections 5 and 11. It applies to any notice that would be given, and we'll just sort of have to wait and see, what the state does in terms of implementing guidance and, how they'll help us to understand, what might need to happen next. The bulk of the amendments that I'm going to discuss are to section 6 and section 10. So variances in section 10. Section 6 generally relates to non-conforming structures and uses in a lot of ways that you're familiar with and in some that you're not. So as the planning board, you'll be aware that the beginning of section 6 has always provided that, a zoning bylaw amendment that you may propose is effective as of the date of the publication of the first notice of your public hearing on an amendment. And that would apply to any projects that did not already have permits issued by that date. And so if you had a special permit application that was pending while you published a notice for a public hearing, that application wouldn't be able to, go through to the end and be issued. Now, this has been amended to read that it shall apply to structures or uses lawfully in existence or to building or special permit or other entitlement applied for under this chapter. And so then they deleted issued. And so what that does is it means, if you've applied for something and the publication notice comes after, you can complete your hearing that may be pending, or the application that's under review may be able to be reviewed. And that wouldn't have been true before. So that's a big change to the way we, catch some of these projects that are coming on the edges of zoning changes. And it does make it, quite a bit clearer, what is the cutoff date for, the building office to consider an application. I think it is a helpful clarification. Now, you'll remember in the Springtown meeting, we considered an amendment to your bylaw, section 6.3, as it relates to existing non-conforming uses and structures. So the bylaw at the time required a a finding by the ZBA that a change or extension of a use is not substantially more detrimental to the surrounding neighborhood, but also that it, was not a greater than 50% increase in things like floor area and a variety of other things. We discussed, last spring that, that requirement exceeded what this portion of the statute allowed for, and so it was simplified to provide for that. The language in red here is a new proviso that further alters the applicability of this section and will cause, some additional projects to be developable without the Section 6 finding. But there's a lot of detail in this couple lines of text. And so, to walk through it, notwithstanding the foregoing, pre-existing non-conforming structures or residential uses that do not conform to zoning because of lot size or shape, frontage, lot coverage, or floor area ratio requirements. So those 5 things are very important. Only if your nonconformity relates to one of those, may your use be extended or altered as of right without the need for the finding, and only if the extensions comply with the current dimensional regulations regarding height, stories, and setbacks. So, to put this together, if you have a non-conforming structure, and only if it's non-conforming with respect to lot size, shape, frontage, lot coverage, or floor area, can you alter it as long as you are not changing or, creating violations of the height, stories or setback requirements? I think this will help some properties on the margins find an easier path towards, conforming development. So if you had a property that, might need a Section 6 finding because of floor area ratio, or, in a community that enforces it, or, where you have an oddly shaped lot, or you just have a compliant structure on a lot that's too small, as long as you have room to do what you'd like to do without creating new setback violations or height violations, you can get the permit from the building inspector now, without needing to go to the ZBA for the finding. And so, there are some situations where it will streamline permitting, but the devil is really in the details, and you're going to have to, not you specifically, but practitioners will have to read this very carefully to make sure that someone who is claiming, the benefit of this exemption, does actually have it. And so, I think the setbacks piece of this is what a lot of people miss, is that you have to comply with setbacks. And if you have an existing setback nonconformity, you're not eligible, because, the list here, these 5 things is very specific. And so if you have any other dimensional nonconformities, you're not going to get the benefit of this portion of the language.
So to turn it around the other way, Ethan, what do you need to get a finding for? And what does the finding enable?
Right. So, as has always been the case, if you are a pre-existing non-conforming structure that, was built 10 feet from your property line, 50 years ago, and setbacks are now 20 feet, you have a non-conformity with respect to setback, and you may not be able to make much of anything in the way of changes to your house, at least in the area where this non-conformity is, without coming back to the special permit granting authority for the finding that your proposed change is not substantially more detrimental. So those are the cases. Setbacks is a good example because it's not one of the things protected by this new language. And so, if you do have a setback nonconformity, you're still going to have to come in for the finding.
And the finding effectively is that it's not substantially more detrimental.
Correct. So
Okay.
that is.
So that's where the subjectivity comes in potentially.
Yes.
And the special permit granting authority in this case is the ZBA.
Yes.
So I'm curious, practically speaking, is it fair to assume that like the building inspector, whoever issues building permits, might be the one to flag to a potential applicant who may not be aware that like, hey, you actually have to get a special permit for this? Like, how will homeowners, what's the process for them to know or to determine if they need to, they call up Julie?
I think that's where a lot of folks start. In many respects, that has always been the case. And the changes we're talking about here have simply, created a narrow set of facts on which the process is even easier. And so, they'll call Julie, they'll come in and, they'll talk to the building inspector and, instead of being told you need to pull together an application to the ZBA, the answer will be, bring in your building plans and we'll see if we can issue you a building permit. But again, it's only in those sort of narrow cases where, they fit into these particular conditions.
Okay.
So I'll continue unless there's any other questions on this. There are a couple of things throughout this that, I'm going to work with Julie sort of afterwards. We're going to need some amendments to your zoning bylaws for a variety of things, and I'll try to call those out as we go through them. This is one of them where, because this language is already addressed in your bylaw, it probably makes sense to have a sort of housekeeping amendment to include this language, to avoid confusion where someone is reading the statute, reading your bylaw, and trying to reconcile the two. So this is one of those things where, your bylaw, we're going to have to enforce state law either way. And so it makes sense to, create conformity between the two. The next paragraph, I'll be honest, I've been doing this for a long time and I've never had this particular paragraph be an issue for anyone that I've ever worked with. It has always said that your zoning ordinance shall require that, someone begins to exercise a building permit basically within 12 months, or the project that was approved will be subject to any, after adopted zoning amendments. Most people, once you get a building permit, you're acting on it fairly quickly, and so it's not an issue. For anybody who has had this issue, 12 months is now 24 months, and so it's an extra 12-month sort of zoning freeze following the issue of a building permit. Not something that you folks are likely to interact with very often. It's going to be really an enforcement question, on the building official's end.
This was probably coming from the sort of push for pulling building permits in advance of the changes to energy code, right? And then sort of sitting on those permits because the projects weren't feasible. I think that's
It could be
from.
that. And there's some other sort of difficult language here. So, the 24-month period shall be told during any time the applicant is actively seeking or obtaining other necessary permits. I don't know what an other necessary permit
You
is.
have the building permit.
Right. So once you have a building permit, I don't know what you could be seeking afterwards. Typically, that is the last stop before you can begin construction. So, again, this will be something that we don't probably have to think about until we run into someone who, has a very unique set of facts, I'll say.
Yeah.
But interesting nonetheless. Here's one that, will require an update to your bylaw. Conventionally, we're used to regarding abandonment of structures as happening after 2 years. So if you have a non-conforming use and you abandon it, the town has the right to enforce zoning if you've discontinued it for more than 2 years. And I believe your bylaw, includes the 2-year time frame. That is now 4 years. And so, if you have a non-conforming use that is, lost for 4 years, for less than 4 years, you can still bring it back. And same is true for, certain structures. I don't know how common this is in Carlisle, but there's other places where, homes that are non-conforming, they're damaged either by fire or by storms. I see this with some coastal communities where a property gets damaged in a winter storm, on the ocean, and maybe they don't rebuild it quickly enough. And sometimes the bylaws don't allow for, reconstruction if they wait more than 2 years. So if you're in one of those situations, that limitation period has been increased to 4 years to, create some additional flexibility.
I've seen it happen in Carlisle.
Yeah. So the next paragraph, this would be paragraph 4 of section 6, has conventionally been applied to vacant lots. And so basically, if you had a lot that had, was never owned in common ownership with any adjacent land, met a minimum of 5,000 square feet and 50 feet of frontage, conventionally this provided that There would be no increases in area frontage width. Basically, any dimensional requirements would not be applicable to that lot for single or two-family residential uses. And so typically this comes up where, someone finds an, abandoned piece of land, in and around other properties that for one reason or another hasn't been held in common ownership since a zoning change that rendered it non-conforming, and you're able to get a building permit for, usually a single family house. Excuse me. This amendment, removes that limitation and, also removes residential use. And so it's not just that it's no longer applicable only to single or two-family residential uses. It's applicable to all lots. And so, if you had a lot in a commercial district or something like that, there are cases now where undersized lots are going to be usable again, where they otherwise wouldn't be. Again, this really only applies to property that was not held in common ownership with any adjacent land. And so, to do this, we have to have an applicant who presents us with, the necessary title information to determine that they are eligible under this paragraph. And so it hasn't really changed the standards. It's just expanded the class of properties that could benefit from it.
Is that not held in common ownership, meaning never held in common ownership?
So the way we look at this, so any increase in these dimensional requirements shall not apply to a lot which at the time of recording or endorsement was not held in common ownership with any adjoining land. The state Supreme Court has determined that at the time of recording or endorsement refers to the, last deed of record or plan of record, basically on record with the Registry of Deeds, that was recorded prior to a zoning change. And so, if you, for example, lived in a place in 1955 where you had 1 acre zoning and you had two 1 acre lots, in your possession right next to each other. And then, the zoning changed and became 2 acre zoning, your lots would merge. And so if you held them together in common ownership, your lots would merge. But if you only owned one of those lots, the effect of this statute has been that, your single lot, which is not touching any other land, could not merge to reduce the zoning nonconformity, remains usable. That's sort of how this has been applied over the years. And so it's usually undersized lots in, pre-zoning subdivisions, honestly. So, when I get these cases, they come up and it's, a 1915 subdivision plan where somebody owns, a bunch of 5,000 square foot lots. And they've been able to identify one or two of them that, weren't owned by anybody else who owned adjacent land touching it. And as a result, they're able to, take out, get a building permit under this paragraph. So that,
Meaning get a building permit as though there was no zoning for it because it was pre-zoning.
so, in that case, if it was a true pre-zoning lot, we typically work with the applicant to comply with the current zoning to the greatest extent possible. And so,
Okay.
if the question is, can you build something at all? The answer is yes. And generally, we then try to work with them to impose, reasonable setbacks as close as feasible to, what is currently applicable. A lot of the time, this arose not when a town first adopted zoning, but, years after, maybe in the, I'll say 1940 to 1965 or 1970 range, where lot area requirements were increasing as were frontage requirements. And so people were very rapidly, becoming owners of property that was non-conforming. We don't have any questions there. That may be the end of the Section 6 amendments. And then, the variance standard, not something that your board works with, very often, but we will be working with the ZBA to, propose some amendments to the zoning bylaw to incorporate this change. You may be familiar that, a zoning variance for dimensional relief has always been a very difficult bar to meet. It's a very high standard. Has been, the case that you have to be able to articulate, a particular hardship relating to soil conditions, shape, or topography that, affect your land specifically, but not the zoning district generally. So it's a really high bar to meet, very particular circumstances to be entitled to it. The legislature has not entirely removed that from consideration, but what it simply is now is that permit granting authority shall, we no longer say that they have the power because, this is being rephrased in a more mandatory, they shall do this. They shall grant a variance, if they specifically find that a strict enforcement of the ordinance or bylaw would result in practical difficulty. Now that's really short, really simple, incredibly imprecise, and I think, you can appreciate that, like many other things, this will be open to a wide variety of interpretations. So, first question in terms of how do we work with this is, what is a practical difficulty? We're expecting guidance from the state on this at some point. There will certainly be, guidance from the courts in the form of, appeals and appellate case law, but it's going to take some time for, everybody to catch up to what this new language means. The ZBA, when thinking about this, will be directed to, in making its determination, shall weigh the benefits to the appellant or petitioner and to the public interest, including the interest in supporting the production of housing, against the detriment to the public health, safety, and welfare of the neighborhood. So this is sort of a balancing test where the permit granting authority that looks at this is going to be asked to say, okay, so on one hand, what good is this doing for the applicant, and does it do anything beneficial to the public interest, such as create housing? So where we talk about including the interest in supporting the production of housing, this is simply one example of a benefit to the public interest. It's non-exclusive. There could be others, but obviously the whole tenor of this set of amendments was to facilitate streamline permitting and make it easier to build housing. That's really been the governor's agenda, the legislature's agenda, and so I think you can see it for what it is. You're balancing those things against the detriment to the public health, safety, and welfare of the neighborhood. Again, so what is the harm that would be done to neighbors, if any? And again, it's very, very open-ended. Board of Appeals may also consider, but is not in any way required to, familiar criteria, whether it relates to soil conditions, shape, or topography, and then whether the strict enforcement would impose a financial hardship on the appellant or petitioner, whether the benefit sought could be achieved by some other means, and whether the practical difficulty was self-created. So there's a couple things in here that are familiar to our discussions that we've had about variances, as practitioners in the past. Typically you're not able to get a variance if your harm is self-created. If you did something with your property intentionally that created a problem, you aren't necessarily entitled to come back and get a variance for it. And this portion about whether it can be achieved by some other method feasible, I think is interesting because it may in some situations give the ZBA a little bit of leverage to say we're not going to approve a really ridiculous request if there's another way to achieve the same ends. So basically giving the ZBA maybe a little bit of leverage to say, hey, applicant, you're asking for a 2-foot setback, but you could really do a 10-foot setback. Let's figure out, what is another means feasible of doing this without, so severely impacting the neighbors. This is it is a significant reduction in the, strenuous nature of the variance standard. It's going to mean that there's going to be a lot of new applications for variances. It's going to mean that there are far more boards across the state that, find applications for variances, fit for approval. Variances get approved all the time, but, very rarely does a strict interpretation of the standard, justify issuing the variance. And I think we're sort of changing the burden now, basically creating a situation where the presumption is that a variance is probably appropriate unless there is some, obvious detriment to the neighbors. A lot to think about. Probably again an update to the zoning bylaw because I believe your bylaw refers to 40A Section 10, but also specifically identifies the conditions relating to soil shape, topography, etc. And so we'll want to discuss a clarifying amendment to restate, what the current standard is, or simply to, state that the standard shall be, as provided in 48 Section 10 as amended, which is language that you see some of the time.
So the way this might come into play for us, since we're not the variance granting authority, is in the context of an ADU application, for instance, where that applicant may need to seek a variance in order to build that ADU, and we would be considering it in the context of the addition of housing, et cetera. Would the ZBA look to the planning board for input on the way the standard where they have to weigh the benefits against the detriments, or would the ZBA consider that themselves?
So, this is a section of the bylaw and a section of the statute that is administered by the ZBA. There's no requirement that they, consult with, any other boards in town. Sort of, it is their standard to apply, and they can make those decisions as they see fit. I certainly, work with communities where planning boards, routinely comment on matters before the ZBA, and so I think, to the extent that's something, your board is interested in doing, or conversely, if the ZBA wants to, open those lines of communication and, seek opinions from the planning board on a variety of things, that could be, certainly done on a voluntary basis. But, strictly speaking, the application of this standard is within the ZBA's authority to do.
And the modifications to our bylaw to conform with these terms, that is our job though, right?
Yes. So, I think there are other bodies that could initiate a zoning amendment. But, I think this is sort of the proper body to be discussing, what sort of housekeeping, I'll call them, amendments might be required by this this set of zoning act amendments. I won't belabor the rest of this. There's a couple other changes. The legislature.
Well, actually, I don't think that last section of that is belaboring anything because it's
Yeah. So
no, I'm not even talking about that. I'm saying except where local ordinances or bylaws expressly permit variance for use.
you're right.
You buried the lead here, Ethan.
Yes, I apologize. I've maybe given this talk a few too many times in the last couple of weeks. Forgive me. So yes, the conventionally variances are available, no matter what, for dimensional relief. And again, conventionally, except where local ordinances expressly permit variances for use, they weren't allowed. And so I think, Carlisle, as in many cases, generally does not allow use variances in your bylaw. And so it's not something that's been considered before. The statute now includes this carve out, no variance may authorize a use or activity other than residential, not otherwise permitted in the district. So this is a significant change, which will allow, a zoning board of appeals to issue a use variance for any residential use, I think. Unfortunately, they say other than residential. Residential is not a term that's yet defined in the Zoning Act. Residential certainly, implies housing, but, I don't know where we draw the line. Is it certainly got to be more than one unit and probably more than two? And so, I think what unfortunately may be the case is that the ZBA has to look at an application for, whatever the residential use is proposed and determine, subject to this standard, whether, a 5 or 6 or 7 unit residential use has, detrimental effects on public health, safety, and welfare of the neighborhood.
So why is it the case that residential means more than one or two family?
I think because it is non-specific, the statute throughout knows how to qualify, single or two-family residential uses. I mean, that is exactly the language that was removed from 48 Section 6. So the legislature knows how to call out, particular kinds of residential uses when they choose to. And again, given the sort of understood objective of this amendment, I'm reluctantly reading residential in this case, to be open-ended. Of course, that doesn't mean that, you know, in
But it
a
would just,
go
sorry,
ahead.
I didn't mean
No,
to
please.
interrupt you.
No, no.
Finish. I was just thinking, so it just means when you're getting a use variance from commercial to something residential or from industrial to, but not from single family residential to residential.
Oh, I think it does include that. And so,
Ah,
if you own land in, and I'm sorry, I should have made that more clear. If you own land in a single family zoning district, I think this means that you can apply for a use variance to build multifamily housing.
got it. Okay.
And, that I think is the thrust of this. There are other current amendments proposed in the legislature at the moment. There's an economic development bill. I am expecting it will pass, and I'm expecting there will be additional amendments to the Zoning Act for us to talk about maybe even this year. That legislation, I believe in its current draft, includes a Dover Amendment carve out for duplex housing. Anywhere that you can build a single family, you can build a duplex is sort of what's being discussed as yet another paragraph in 48 Section 3. We're not there yet. That's not what's in the document I'm discussing, at the moment, but certainly the legislature is chipping away at the, concept of a single family, residential zoning district. And, I'm not saying it's a good thing or a bad thing, but that is certainly, what the effect is going to be, at least in many cases.
And so to follow a thread here, then, you can get a use variance to residential. There's still underlying dimensional regulations, right? But you can get variances to the dimensional regulations by showing some kind of practical hardship.
Yeah.
But there's still the stand. Well, it's they have to weigh the benefit against the detriment.
Right.
Interesting.
So weigh the benefits to the appellant and to the public interest, such as housing, against the detriment to the public health, safety, and welfare of the neighborhood.
But there's no, does one weigh 5 pounds and one weigh 1 pound? And you're like, how many pounds are you putting on either side of the scales, right? Like there's nothing,
And
that's where the subjectivity comes in.
that is unfortunately the decision that's being, put upon every, zoning board of
Right.
appeals in the state right now.
Yeah.
Is how do we look at something and say, is there a practical difficulty? And what does that mean? And then, how do we balance the other things? The week that this statute was amended, I had to give some very quick advice in one case where a property was seeking a variance solely because it failed to satisfy required lot width. It had the required frontage, it had the required area, the building on the property satisfied all the dimensional criteria, except that lot width had to be measured through like the center of the building, and it failed to have the same lot width in the middle of the building as it did at its frontage. And, as a result, it was short by like 7 feet. And so, that is, I think, a good example of a property that would not have qualified for a variance necessarily under, the original standard. Maybe you can call it a lot shape issue, but it really wasn't. It's just that the, lot was not as big as it needed to be. Or, maybe that the house was built in slightly the wrong location on the house for a, beneficial measurement of this, criteria under the particular bylaw. But, now with this more liberal standard identifying a practical difficulty, where everything is otherwise conforming, I couldn't think of, any issue with public health, safety, or welfare to the neighborhood of granting a 7-foot lot width variance where, there was already a building on the property, in fact. So, I think there are a lot of cases like that where very minimal relief may be sought. It might allow people to, take one lot that could be A&R'd to create two lots. There's a lot of things that I think are fair game that wouldn't have been before. Conventionally, we couldn't issue variances for frontage to create multiple lots. You could maybe get a variance to make one lot usable, but you couldn't get a frontage variance to, create two lots. That wasn't really something that the courts
Right.
allowed. And so,
Yeah.
I think that sort of goes out the window here where, practical difficulty and, benefit to the, applicant and, public interest is the standard. But, I'll couch all of this to say that there's a lot of guidance that will certainly be coming from the state, and people are going to be applying for and getting variances that are going to create litigation, whether they're towns that are denying them or neighbors that are unwilling to you know deal with the realities of this amended statute, at least not at first. But I think, we're probably, still a couple weeks or months away from getting guidance from the state. And, I'll guess we are, I don't know, 2 to 3 years at least away from seeing any appellate decisions on, what this language means.
Okay. Any other questions from the board on this stuff at this point before we move on?
No, thanks, Ethan.
Yeah.
Did you cover everything we needed to cover in your memo here? Looks like we did.
Yes, I think I did. There was, Section 10 relating to variances used to include a paragraph that expressly authorized conditions, safeguards, and limitations. The legislature has deleted that paragraph, so we are now left to infer that, the authorization to impose conditions is either implicit in the ability to grant the variance, or we should be reading the deletion of that paragraph as a signal that we shouldn't be putting conditions on variances at all. Until I hear otherwise, the advice I'm giving to clients is that reasonable and appropriate conditions, can and should still be imposed. But particularly where there is now an argument that the legislature, may have attempted to remove that authority, we had better be very careful that conditions that are being considered are, in fact reasonable, are, demonstrably related to, identifiable problems caused by, the relief that's being granted, not, so many other, wishes or asks that many boards, not specifically anybody here or anywhere else, but, there's a lot of room to ask for things that, might benefit the neighborhood. And I think the deletion of this paragraph makes it harder to justify some of those.
Makes sense.
Yeah, so I think, stay tuned. I'll be in touch with Julie and, planning board and ZBA anytime there's more guidance from the state. I'll certainly be in touch again, if and when the economic development bill passes. That includes a number of things. I mentioned the possibility of Dover protection for duplexes. It might include codification of site plan review. That's included in one of the drafts, and so we could be looking at another set of pretty significant amendments, and a bit of work to make sure the zoning bylaw is up to date, and everything is works together in a reasonable way.
Okay. Anything else you wanted us to cover, Julie, with Ethan here?
I don't think so. I think that's everything. Thank you, Ethan.
Thank
Yeah,
you, Ethan.
absolutely. All right. If you don't have anything else for me, I'll let you go and wish you all a good night.
Can I ask a quick question?
Yeah.
Just so hypothetically, if one of these situations arises and it goes before the ZBA, I assume this overrides everything. So it's going to take a bit to update our bylaws. Just there's only so many time meetings. So essentially, with potentially more changes coming down from the legislature, we should kind of hold a little bit and make all the updates at once?
I
Or like how pressed are we for timing, I guess is my question.
that's a good question. Certainly, I can talk to Julie about it, but my thoughts at the moment are that none of these are so pressing that you need to scramble to pull it together for the fall town meeting. Some of them might be simple enough that if you want to, it's not a huge lift, but state law will supersede any, conflicting provisions of your zoning bylaw. And so, we're not applying the old variance standard. We're going to apply the new variance standard. And, there is some confusion that could result if someone, reads your bylaw and doesn't understand, what they have to then present to the ZBA. But, we're applying state law, and that's going to be the case, whether we amend the bylaw or not. And so, I think you don't need to feel pressed for time to do this for the fall town meeting. You could if you want to. But it's also something that could be done, I think, for the annual next year. And that would be, sufficient time as long as all of your, staff offices who deal with these applications on a daily basis are able to, communicate with each other, communicate with my office, and, help applicants to understand what they're going to be needing to do, because it's a big change for everybody.
Okay. Thanks a lot, Ethan.
All right. Thank you all. Have a nice evening.
Thanks. Good night.
Thank you.
Bye now.
Okay. We obviously have the other two topics in the zoning discussion, that one of which I think is really just punting until we have Dwight back, right, Julie?
Yeah, if that's how you guys
Foster
can handle
Garmis
that
and-
one. Yeah.
Did you want to speak to anything on the distinctive structures bylaw?
Do you want me to? I can screen share it. It's come up at a couple meetings recently. It was some ideas. I don't even remember when we originally kind of started thinking about this. But some of these ideas have been in the back of my mind, in terms of maybe like a more surgical approach to allowing certain structures to be able to be adaptively reused, or repurposed. And so I had sent this around in June, and then you didn't talk about it at your last meeting. But I haven't changed it since then. So, I had a couple different ideas of maybe how to allow a little bit more in, town-owned structures or on town-owned properties. And that related directly to some thinking that was happening during the MBTA communities discussion. But of course, this isn't to that extreme, right?
Right.
And then one was just kind of looking at what we allow in general residence districts and just adding some language in for multifamily and mixed use on town-owned properties and in town-owned buildings. And then another way to kind of get at a similar approach, but related to historic structures, is to actually look at the distinctive structures bylaw. And to be a little bit more expansive with what's allowed there. So right now, it's currently section 3.2.4 of the bylaw, and it refers specifically to non-residential buildings that have been in existence since 1932, and allows them to be repurposed into different types of uses. But it doesn't specifically talk about town-owned buildings, and it doesn't specifically relate to residential buildings. And so I was thinking in terms of like the Bog House and the Highland Building, and how there's been ongoing discussions about what to do with those properties. And at least in the case of the Bog House, we're working on, potentially converting it to affordable housing, but there's no zoning mechanism to allow that to happen. So the option right now would be the friendly 40B. But there may be a way to actually do something in zoning that's more surgical and strategic that relates to the Bog House specifically. So that was kind of what I was contemplating with the few kind of changes to the distinctive structures bylaw.
And I think the other thinking with it was farmhouses with accessory use, extensive attachments involving, barns and the like, and being able to potentially repurpose those buildings into multifamily. This is a special permit process, right, for the distinctive structures.
It
And
is, yes, it is currently.
um, rather than by right or site plan review. Um, and so the thinking was, and I think it's useful to in this meeting sort of just socialize it more broadly. I'm not sure, um, Chris, Stacy, and Sarah, um, if it's been I know that some of us have talked about this separately, and we talked about it a little bit in the context of MBTA, but we should be thinking about whether or not we think it's a worthwhile pursuit to try to amend the bylaw in this way to allow for the reuse of town-owned structures as well as non-town-owned structures that may have existing square footage that could potentially become repurposed as multifamily units, so barns and the like. Has anybody had a chance to really dig into this language and have any specific questions, any broad questions, thoughts, concerns?
Well, I looked at it a bit and it felt like there are two options. There's like the multifamily housing on specific town-owned properties or a distinctive structures approach, right?
Yeah, that
Was-
was how I had kind of laid it out, and I don't know that you would necessarily need to do both. The distinctive structures section wouldn't include properties like Banta Davis. So there has been talk about, some sort of mixed use, community use, housing use on Banta Davis for many decades now. And again, like there's no zoning mechanism to allow that. So in looking at some of the things that are outlined in the master plan and trying to get ahead of like, okay, if we do end up really pursuing some of these bigger picture planning initiatives, like we could start to kind of lay the groundwork for how that might work in terms of zoning. But the distinctive structures section of the bylaw wouldn't necessarily cover the properties that the town owns that don't have distinctive structures on them. So,
Okay, yeah, that makes sense. So you've really got two approaches for two separate issues, or things that we'd like to have mechanisms for.
Right, but if we don't necessarily want a mechanism for the non-town-owned properties, then we don't necessarily need the distinctive structures aspect of it. We can just go with the first option, which would cover town
Right.
structures and town-owned properties without structures.
right,
Yeah.
correct.
But I did like the distinctive structures also because that would give residents more flexibility too.
Right. Yeah. Sorry, I keep scrolling back and forth. I'll stop doing that. You just tell me what section you want to look at. But yeah, that is a good clarification, Addie. So the distinctive structures bylaw would pertain to more than just town owned. In fact, I added town owned in because it wasn't clear that it meant to include town owned structures. So.
Yeah, though I'm just sort of wondering if this new zoning, this new state stuff that we've just been talking about with Ethan creates a pathway for a lot of what we're trying to achieve here that doesn't need to be enabled by anything because it's already enabled by those changes.
I would caution a little bit that like the state law feels like a little bit of a blunt instrument, right? So that would be an approach someone would take if there weren't a good alternative already in the
Right,
bill.
right,
So if we
right.
had
And
something,
you're still at risk to the
Right.
weighing of the benefits versus yeah.
So
And you
is
can-
there a good example to use, like something like Highland Building, and not Highland Building, South Street, like Assurance Technology, for example, right? That's if somebody wanted to convert that to multifamily housing, there's currently no zoning mechanism to do it other than a
40B.
single family residence with an ADU, right? So
Or 40B.
or a 40B.
Right.
So this would be one way that we could, sometimes it's just helpful to think through concrete examples of things
Yeah,
that we
absolutely.
thought might make sense. So
Yeah.
I think in that context, something like this would make sense.
Yeah, and I think that this is also a really, I think it's helpful to think about the demo delay, or sorry, I know it's not called that anymore, but the
Review.
Review.
demo review in the context of enabling enabling structures that might be impractical to keep, right, without the right zoning to allow you to use those structures or those components of historic structures as in a way that is productive, I guess, or enables you to afford the upkeep of that historic structure. It to me there's a hand in hand thing here that I think can be useful to think about. Not that we'd be able to get this in front of town meeting at the same time as the demo review proposal, but I like the idea of creating opportunity out of restriction, right? So if you find yourself the owner of a property that would be subject to demo review and you're thinking, well, I have this component of this property that needs a lot of money in order to maintain it, and I just want to demo it to get rid of it. But if you have an option to repurpose it into something that zoning allows you to do through a special permit, that can help with the impact of demo review, right? And help Historic Commission get to an outcome that they hope for, which is that the demo review enables another solution to be found aside from demo.
Yeah.
I'm kind of speaking to Sarah directly on this. I'm not sure if she's agreeing with me or not. Can't read your
No,
face.
absolutely. No, I think
Okay.
that makes perfect sense.
One of the things that I think, and I haven't looked super carefully at this language, but I think it's worth spending some time thinking about is what the bylaw will say as it relates to not just the structure but the site plan. And I don't know that it does that. It may, but I would want to make sure that we don't, pre-existing structure and reusing that pre-existing structure doesn't necessarily imply that you are also reusing that pre-existing site plan, right? There may be changes. So let's use the Bog House as the example, right? Like if this were a mechanism by which the Bog House would be entitled, we'd want to make sure that the whatever way that this bylaw gets written creates language around site planning that achieves what we would want to achieve. So in the case where, for example, we would have to go to an RFP without having a very specific design, in order to preserve the option for a developer to not have to go through a public procurement process, right? Because this is the two options that we were talking about with Select Board last week or 2 weeks ago, whatever it was. You'd want to make sure that the bylaw as written for distinctive structures creates enough restriction and not restriction, but regulation around what that site plan outcome ought to be so that you can have um, I guess my point is we don't want to lose the site plan discussion in the context of the structure discussion in the bylaw.
Yeah, so
Making
I
any
sort of,
sense? I'm sorry.
no, it does make sense. And I was thinking about that in terms of like the current distinctive structures is by special permit from the zoning board and doesn't include the planning board or mention site plan review. And so I
Mm.
kind of did think that adding like having the jurisdictional board be the planning board and then also having it be a special permit and site plan approval as a combined so that it's
Yeah.
clear that the site plan does also matter. And then you have you have your site plan regulations and your submittal requirements, and we can look at that and make sure that they're actually fine-tuned to what it is you want for something like this. But that's
Yeah, but I
a
think it's more
starting
than
point.
yeah. I think that, and I think that's great. And thank you for pointing me to the fact that you've already considered this and astutely considered the fact that there's no mechanism to get it to planning board in the first place, so that we'd have to change that too. I think what I'm trying to get at is would we want to put in not just and then maybe it's not possible to do it this way, but I'm trying to get at like, do we want to be specific about what the site plan needs to do within the distinctive structures bylaw, as opposed to just that it's subject to site plan review, and we've got regulations around site plan review, right?
Do you think that through your site plan process, you wouldn't be able to get something to do a site? Like, I was worrying about being too prescriptive up front because every site's going to be a little different.
Different,
Yeah, I hear
If you
you.
have your process and then through that process, you
Right.
like, unless you have something really specific in mind that you're thinking about that would apply kind of across the board, um, that would be something that you could like
I guess I'm just getting hung up on the very specific concerns that folks have about Bog House site plan and the uh the planning around access to the open space, parking for the it's um it is very specific to Bog House, I suppose, but maybe there's some language relating to open space adjacencies and um,
Mhm.
facilitating access or something like that.
Yeah, that makes sense and probably should be in all your site plan sections for any development that has open space adjacencies. I think,
Yeah.
yeah. Okay. Sorry, I'm just writing some notes.
Is it useful to have any further discussion around this right now? I see we have at least one member of the public who would like to chime in. Julie, should I just go to Christina?
Yeah, I just asked her to unmute.
Okay.
Hi, thank you. I am so excited about this concept. I think it's such a great approach. I think it's an environmentally sensitive approach. Obviously, devil's in the details, but as a concept, it is such an environmentally friendly approach. And I also think that it is a gentle approach that is less threatening for people who might be a little more resistant. It's a gentle way of easing into the concept of increasing density without having huge negative impacts. So I just wanted to say yay.
Christina,
Thanks.
I'm sorry if you
Oh,
don't mind stating your name and
yes, I'm so sorry.
it's
I should
okay.
know by now. Christina Chrysotolopoulos, Hemlock Hill Road, co-chair of the Environmental Sustainability Committee, but I'm just speaking for myself. Thanks.
Thank you for that comment, Christina. And I would ask you to consider maybe with the with the Environmental Sustainability Committee, anything you would advise us on to consider in this, whether it's percentage reuse of the structure or other environmental considerations, any downsides you might see, any often with these types of things, you get into unintended consequences or unintended outcomes. So, would welcome your perspective on those things for sure.
Thank you so much. And if Julie is willing to share the language, that's a great jumping off point to spark people's thoughts, if that's okay.
Yeah, that's great. And I'll put it on the website too. I meant to before tonight and I didn't get to it, but I'll create a page for it on the planning board webpage.
Thank you.
Sure.
Julie, can I ask a quick question? How did we get to the 1932? Is that just where was that? The date that's defining just a question.
Yeah, that's already in the bylaw. It's not a
Oh,
problem.
okay.
Yeah, I think it might be around the time the town first adopted zoning, actually.
Okay.
But I can do a little AI history on that date and probably get a better answer for you for the
That's
next
okay. If it's
meeting.
already in the bylaw, that was sort of the answer.
Yeah, it's already, so it doesn't necessarily align with like demolition review bylaw or
Right.
any list we have necessarily, but
I guess the question is, would we want to rethink that date, right? Because I assume that like Historic Commission might have a perspective on, particular structures that it would view as distinctive in town that are younger than that.
That was kind of my point, is do we just
Right.
want to make sure that we've sort of, you might want to share it with Historic. It might be a good collaboration just to make sure that it catches all the distinctive structures that we think might make sense for
right. Yeah, that's a good
for
point.
this bylaw.
Does Historic Commission have like an inventory of particularly distinctive structure of structures and properties in town that it views as being particularly of value?
There's the ones on the historic inventory, but I don't know that I can really fully speak to that, but I think we'd want to think about, I'm thinking of like barns and agricultural buildings and things like that might, I don't know, I think we just want to think through what that list is and make sure this kind of covers what we're intending to do with this bylaw.
Right.
But I don't think there's a list other than the historic inventory.
Yeah, and the historical commission members like routinely say that the historic inventory is incomplete.
It is.
And it does appear that the study that was done that created it like wasn't actually finished.
Mhm.
And so it's missing a lot of it. It's missing the two structures that are on the National Register, for example.
Oops.
Yeah. So and it has some other deficiencies as well.
Yeah.
I think it also, at least the data layer that I remember seeing at one point during the MBTA communities process had included some structures that no longer existed.
Right.
Yeah, so I guess you don't want to put the onus entirely on the Historic Commission to identify explicitly the properties that this would apply to. But you also don't want to preclude things that are important to the Historic Commission by setting an arbitrary, or not arbitrary, but a specific date that may not allow you to capture those.
Right. Do you want to potentially consider this for Springtown meeting?
I think so. I think it's a whole lot more straightforward than the clustered ROSC stuff. I don't know. Do we think it's too much to try to do 2 bylaws in Springtown meeting?
Were you still thinking of clustered ROSC for Springtown meeting as well?
I think we were. Were we not? We were gonna try, at least try.
I mean, I think that's why we asked and Dwight offered to put something together, right? For us to frame the conversation and start to explore it. I think what
Right.
I'm wondering is, given that we might also have a number of zoning changes because of state law,
Hmm.
and there could be a lot that's landing in the spring meeting that
Yeah.
like I yeah, the 48 changes so far are like, I don't know. We got to get our heads around that a little bit. In some ways, maybe it's
In some way, there's
not.
nothing we can do about it. We just gotta comply and conform. But in other
That's
ways,
true.
it's also I think it is a communications challenge to um, help people understand what it means so
Right.
that um,
Hmm.
we don't find ourselves in the position of not amending our bylaw and being out of conformance with state law because town meeting votes not to amend because they don't understand it, right?
Yeah. Yeah.
Um, so it may be a very heavy lift to do the communications effort for the stuff we have to do plus the stuff we want to do.
And the stuff you have to do might also increase with the economic development bond bill.
True.
Um, and so
Yeah.
I actually was thinking this came up regarding the zoning change that was made at the Springtown meeting, that it might be worthwhile to have town council kind of just audit the entire bylaw, because there are some other things that are in the bylaw that I don't think fully align with state law. Um, so while we're talking about aligning the bylaw with new changes to state law, it might be good for them to kind of take a look at the whole bylaw. Um, do it all in one kind of like one town meeting where you're focusing on alignment with state law. Um,
Yeah.
yeah.
Kind
I
of
don't know.
feels like that's a fall town meeting kind of topic though.
It does. It kind of feels like next, maybe like, because
Next
I
fall.
don't know that you're gonna know, just given the amount of things that the town usually does in the lead up to a town meeting, I don't know that you're gonna know about the economic development bond bill and have
Yeah.
enough meetings to kind of handle that, especially if the DPW project, comes before you in the fall, winter, right? Like,
Yeah.
unless you add
Yeah.
another
Okay.
meeting every month, I mean, it's aligning the things that we know are coming with the bandwidth of the board.
So I think what I'm hearing then is the possibility of um, next year's annual meeting being for the things distinctive structures, potentially ROSC, and next fall for alignment of zoning language with state law, because we'll know more, and there will probably be some case law maybe by then that will clarify some parameters that are not clear right now.
Yeah.
I think that makes sense.
That sounds right.
Yeah.
Yeah.
All right.
Okay.
Sorry, I'm just making a note. Okay, great. So I can rework this a little bit with some of the feedback from tonight and put it on the website and then put it on your agenda for September for another discussion, if you think that's good.
Yes, I think that makes sense.
Mhm.
So the September meeting is September 14th.
Okay.
Yep.
Do we want to dive into the minute from last time?
Sure, let me just
Sure.
pull them. So Stacy had sent me some amendments. Um,
Okay.
so I'll pull up that. Um, I feel like that's good.
You had your work cut out for you with this one, Noel.
Yeah, it was a little long, but it's all right. I have the help of the computer now. So the formatting looks a little off on this because it's converted to a Google Doc. So I'll just start with the amendments. All right, so Stacy said this. Stacy asked that question, so just change that. Um,
I got the same one, the Bearfield.
yes,
Yeah.
correcting the last name.
So do a search because I think in the additional attendees on page 1, if you didn't catch it, Bearfield
Okay,
there will also need the change.
okay. And then
I had
this
something
one,
on. Okay. Yeah, keep going. So he and she needed to be fixed there, huh?
yeah. Um,
I had something on
you say
top of page 7, I think.
7. Okay.
It's the comment up from Abigail Zimmerman.
Was it enthusiastically?
No.
Because I was like, well,
Yeah, it's interesting what the AI does, right? It
yeah.
was renovation. I think it means it's supposed to be rehabilitation.
Yeah. Oh, yeah, renovation. We're not renovating
We're not
anything.
renovating the wildlife. And it's probably not projects either, just wildlife care and rehabilitation, I think.
Yeah.
Yeah. Okay. Barbara kids. Okay. All right. So for this question or this comment,
Mm-hmm.
had said it had been approved under Dover Amendment. Um, and it was building commissioner's opinion. So I can rewrite this to say, gotten the opinion from 2 other building commissioners.
I don't even know if I actually said that.
Yeah. I mean, I don't want to suggest I know exactly what it is, but
Okay. I can just kind of scratch it if you
I
want.
yeah, just take everything out after the run-on and there, which comes after a period anyway.
Okay. Yeah.
Um,
Yeah.
because it was really the
yeah.
applicant who chimed in and said that at that point, as I recall.
Right.
Hmm.
Yes, correct. It
Okay.
was the lawyer, the attorney, I think.
Mm,
Okay.
great.
Scratch. I think that might have been it from Stacy. Let's see. yeah, I think that was it. So did anybody else have anything that they noticed?
I had one minor thing. I'm looking for it now. Okay, so but it's kind of spans two different pages. What page am I on? 5. So um so okay, yeah, right there. Akshay Jain. So that
Yes.
one's probably all correct, but you'll just note that Akshay Jain is all a masculine pronoun there. And then there's another Akshay Jain further down. And I think it was a different person on page 7. Um,
Oh, and that's a her. Yep.
yeah.
Woman or a man.
Oh, okay. So I will.
So, and I think I might know the name of the person who it is. I think it's Shaylee, but I can't be sure, of course. I'm just not sure. But I think it's Shaylee, Shailly.
Well, that person wrote, didn't that person write a submission to the planning board in a letter?
I think so.
So we know the spelling of that person's name from that, but we don't know if it's a male, man or a woman. Is that the issue?
Yeah,
That will.
yeah, I'm just pretty sure. Yeah, I mean, yeah, I suppose you could
Okay,
put
so
that in, but I do think they were two different people, though.
Oh, you're saying that it was
okay.
the first one was one of the Janes and
Yeah,
the second one was the
Akshay
other one of the
Jain is,
Janes?
yeah, Akshay Jain, I think is correct, and I think that was, um, the husband, and
Oh, okay.
And
Yeah,
this,
yeah. So it's just okay. I understand. So this was I do now that I'm like reading it, I remember visually who said it.
yeah,
So I
yeah,
understand what you're saying. It's like a husband and wife. So I'll figure out the names. Um,
I know that's kind of a complicated thing to have to explain anyway.
yeah, and sometimes people don't have their names like at their address, so it'll be like in a trust or whatever, and I'm like, I
Oh
don't
yeah,
know.
yeah.
So I will I'll do some digging tomorrow and see if I can find their names, the first name.
It shows both their names on
Oh, it
Access.
does?
Yeah.
Okay.
So you can
So,
get the
Yeah.
spellings.
great. Thank you.
Mhm. Yep.
Yeah, I think it's
Um,
Shailly
Mhm.
for her.
okay. Um, so is there anything else? All right.
all right, I'll take a motion to approve the minutes of July 13th as amended.
So moved.
Second,
Roll call vote.
Gigasai.
Grady, aye.
Lennon, I.
Smith, aye.
Hey. Any other staff updates, liaison reports?
I have a bunch of things I can tell you about, but I don't want to presume you want to know all of them. And I don't want to get ahead of liaison reports if people have other interesting things to share.
I think Magic has been on a summer hiatus, right, with their next meeting in September. So
Yes.
nothing from there.
Okay.
And I will, as the select board liaison, I did attend a recent select board meeting to, listen in on and contribute to the discussion related to the Bog House and the process there that was being debated and considered among the select board to determine, basically whether we were throwing good money after bad in continuing to pursue that process, given that there was some concern that the ultimate build out would have to be subject to prevailing wage, and that might make it uneconomic. I think I was deliberate in not speaking on behalf of the planning board, but weighed in on just sort of my experience with development more generally, and the fact that these things evolve. And I think town council, Tom was there, as well as
Jenny.
And they did a really great job of kind of explaining how the process could advance as if we, the town, have a lot of control over the outcomes there, and there's ways in which things can pivot or be adjusted as we go along, but that ultimately, in order for anything to happen with the Bog House, the Article 97 land swap process has to go forward. So I think that was a good outcome. And then the other thing is that the select board has published their goals. They were published in the Mosquito on Friday. I haven't dug into them closely, but I do know that the select board has a goal that involves something they're referring to as Connected Carlisle, and it's sort of an initiative to try to bring together sort of plans and strategies and various work that has been done over the years around pathways and sidewalks and interconnection from the standpoint of pedestrian infrastructure, as well as looking at infrastructure in the center that may be, public water supply that can serve multiple town buildings, as well as a denser downtown area, town center area, sorry, and potentially interconnection of a publicly owned waste treatment facility. So, sorry, I've dropped my fidget toys. I think the next step really is I'm going to ask Christine to come and speak to us about how we can support the select board in this process. And just to add more to our plate, I suppose. But I think there is a role for the planning board in this, in trying to consider broadly, what are the ways in which we can plan for a more robust interconnection of infrastructure. Do you think I got that reasonably accurate, Julie?
Yeah, the only thing I would add is like coordinated facilities planning. Most of the town facilities are proximate to the town center, so just better coordination and connections between the sites.
Right.
Yeah.
Right.
And these things tie to the master plan, many of them, if not all of them, in some way or another. So
yes, that's a great point.
Yeah.
Any other liaison reports?
I guess this isn't a liaison report, but it's kind of related. I was planning on going to the select board. Since you brought up the select board, I was planning on going tomorrow night for the hydrogeology survey. So I was wondering if anybody else was going to be attending.
I think
You
I
all,
have.
I'm hoping know what he's talking about.
I'm sorry, say that again.
The subsurface
Yeah.
hydrogeology mapping project. There will be a presentation from the consultants to the select board tomorrow night. It's scheduled for 8:15. And they meet in the Clark room and on Zoom. So that was a 3-year long effort that would not have happened if we had not hired Noelle. So
Yay,
she
Noelle.
deserves a lot of credit for that effort. Just her diligence in using every spare second she had while I was really focused on MBTA communities last year to work with Linda and get plans out of files and read the plans and create a massive spreadsheet of data related to depth to bedrock, depth of well, I mean, all the different data that's gathered for wells and septics and test pits and well drillers reports for over 250 properties in town. It was enabled the project. That was the foundational work that enabled that project, that grant money to be spent. So Noelle deserves a lot of credit for keeping that
Thank you
effort
very
moving while
much,
I had
Noelle.
no bandwidth for it. So
Thank you for the praise, Julie. I appreciate it.
I hope to be able to
It's
say it again
huge.
tomorrow night. But
Yeah, no, I've been looking forward to it for a long time.
It was nice to see the maps that they produced. It's like finally the effort paid off, like behind the scenes.
That's awesome.
Yeah.
I'll definitely try to be there.
Julie, correct me if I'm wrong. I think we can all go where, like, there won't be any discussion. So there's not a problem with a couple of us going, right? We're not going to create.
Yeah, no, you can definitely all attend. And if some of you are on Zoom and some of you are in the room, that should be fine. Because you won't be having your own separate.
Right. We're not presenting it. This is, yeah. Okay.
Yeah, should be okay.
Oh, so we don't have to worry about creating a quorum?
I mean, I haven't posted an agenda for you, so if there is a quorum of you there, like in person, like if someone goes home and gets on the Zoom, that would probably be ideal.
Yeah.
But
I believe as long as there's no deliberation, you're
Okay.
allowed to be in the same room.
Yeah, I think that's correct. As long as we're not deliberating, that's my
Maybe as
impression.
members of the public too. So,
yeah,
Okay.
Right.
yeah.
Well, then I will tune in.
all right. That's
Thank you both for all your work on that.
Thank
Yes.
you. Of course.
So I have a few other things I can kind of mention to you guys, if now's a good time. Okay. So the fire station project, we had a pre-construction meeting with them last week. They have begun site work. The first thing they need to do is drill the well before, and that's one of the many things they need to do before they can get a building permit. So they're working towards that with the hope that they can pull a building permit at some time, I think, early to mid-September. So that project has started. We are in town hall. We're next door, so we hear everything that's going on. We can see out the windows what they're doing. So there's a lot of oversight. And then John Mativier and I are working together with other staff to make sure that the conditions of the planning board permit are met throughout the course of the construction. So there will be more on that, so stay tuned. The DPW building committee had a meeting last week. I believe that the select board is going to be reviewing a contract with HKA. They're the selected designer. In the meeting last week, I was given the opportunity to ask for a few adjustments to the language to accommodate land use board involvement during the schematic design phase of the project, which I think will be critical to enabling you to have input at a high level before the design is a fait accompli. So that when it does come through permitting, you've seen it, you understand it. Hopefully your high level feedback has been incorporated and the process through permitting could be maybe a little more, little smoother maybe than the fire station project. A little more kumbaya, let's say. So those changes were accepted by HKA, by Ryan, and I believe the select board will review the contract tomorrow night. The DPW building committee is having another meeting on August 27th. I will be away, so if somebody from planning board can volunteer to be there, I can loop you in. I don't know the time yet. There was no time set for that meeting. They have been meeting during the day. And I can reach out to you offline, but I do think it's important for someone from planning staff or the planning board to be involved in these discussions, or at least hearing what's being discussed at these meetings.
I
For
would agree,
content.
but do they always meet during the day?
So they have the recent meetings have been during the day. Yes. Yeah. So let me see.
I think the challenge of having a planning board member there is the potential interpretation that whoever is attending is speaking on behalf of the board, right? I would prefer there to be a staff member involved.
I can go and report back if you'd like.
I think
I
that's
can
great.
attend the meetings if you'd like.
Yeah. Okay. That's great. Thank you, Noel. Appreciate that.
Thank you, Noel.
You're welcome. Right.
So the Addie kind of gave a little overview of the Bog House procurement discussion. So the sentiment from the select board was to stay the course. So we're still working with GNAP Architects on schematic designs, and we're working with Land Tech on a site plan. They have revisited the notion of putting the new septic system behind the house, which even designed per the local Board of Health greater design flow requirements will fit in the area that's outside of the wetlands. It's a tight fit, but it will fit there. And then they're exploring an alternative system. So it's a Presby system, which requires a smaller leach field area. And so it will fit even easier in that space. It's a system that's been used in town that was actually recommended to me by Linda and other members of the Board of Health in prior discussions with them offline about the Bog House. So in their site planning process, what that means for the town is that our carve-out area could potentially be smaller. And then we could explore the option of using the neighboring bogland for nitrogen credit. So you probably all remember some of the discussions last year about the land area matters in terms of how many bedrooms you can get from a septic standpoint, but there is in Title V provisions that allow for nitrogen aggregation and using land that's adjacent and in the same aquifer, and I think down gradient. So Land Tech is exploring that, and I hope to have a site plan kind of more pinned down from them later this month or early September. And then we do have a contract with an appraiser lined up. So I'm coordinating a site visit between the appraiser and the engineer, and also a staff person at the Executive Office of Energy and Environmental Affairs. Hopefully for not next week, but the week after. So they can all come to the Bog House and kind of look at that land together and get a sense of it. And then let me just screen share really quick. The site that's being talked about as potential replacement land is, can you all see my screen? Let me just make it.
Yes.
See if I can make it bigger. Yeah, this is the Conant land here outlined in yellow. It's the land where town hall is, and the fire station. And then this is the well to support the fire station. And then some land in this area, right? Not necessarily the entirety of the land that's encapsulated in this white circle, but this is just to give a sense with frontage on Rockland Road, the Castle Rock, like outcropping, some trails and some wetlands. And this was discussed with the select board last month, and it seemed generally favorable as the land that we should be looking at in terms of replacement land. So this land, when I say replacement land, it would be the swap for carving land out of Article 97 for the Bog House project, and this land would go back into conservation. So it'd still be town owned. It would just be conservation land subject to Article 97. So this is the area of Conant that we'll be looking at. Does anybody have any thoughts on that? And it may, I should say, it may also extend up to here so that there's an adjacency with the CR that's being worked out on this property here. And then also just continuation of the trail.
I'm sure the Trails Committee would approve.
I'm not.
What's the timing of the appraisals that are underway to try to solve this question?
So the site visit would be maybe the week after next, and then we will need to get the appraisal at some point in September or October. It needs to be with a sufficient time in the lead up to town meeting to kind of understand what we're talking about in terms of value.
But I mean, I guess a decision has to be made about where the septic location is, right? In order for the appraiser to know what they're appraising.
Yeah, so I am trying to get on a Board of Health agenda for September. Board of Health, Trails Committee, Conservation.
Yeah.
Like, I've got a whole bunch of scheduling that I'm working on.
I do remember now that you said that the Trails Committee has some objections, but hopefully they can.
Well, yeah, I mean, one of the possibilities that hasn't really fully been fleshed out yet, so this is just very conceptual at this point, is potentially recommending that the nitrogen credit easement be over the dragonfly habitat area, which would give it additional protection. And so that might be something that,
Oh yeah.
there's
Yeah,
trade-offs, right?
Yeah.
So we're trying to be smart about this, and it is an aggressive time frame. And I will be attending a lot of meetings in September. So
Yeah. Okay.
that's the Bog House update. Let me just see what else.
Amazing how much work goes into these things, isn't it?
It is.
Incredible.
So I develop big projects. It's generally the same amount of work.
Well, yes, I would agree. It's like when you move your house, right? You could either move to a whole different town or you could move next door, but you're moving.
Yes.
You're still packing all your stuff.
Right.
Right. The FinCom has begun the FY28 budgeting process. I received a memo late last week from them, so they're looking at it. They're looking for a 5-year projection. I'm going to dig into it a little bit more and then put it on your agenda for next month, because we should probably talk about whether we want to make any requests for consultant funding to support any of the bigger picture master plan related planning initiatives, some of which have come up tonight already. And then we should talk about the future of the GIS program as well. So that'll be on your agenda for September. If you're all amenable to a little bit of an overview of our Prophecy Gov AI tool that I have at my disposal in Town Hall, I can show you really quick some of its capabilities, and then you can dream up research projects for me to feed it.
Let's do it. I'm sure Chris especially would love to know about it.
I just want to share, let me just make sure this works. Okay. So can you guys all see Prophecy Gov on the screen?
Yep.
Okay. So earlier this year, the town entered into a contract with this company. It's a large language model built specifically for municipal governments. It enables us to research. It will research things, it will draft things, and it can also do benchmarking. But basically, I've been using it to research. So what it pulls from is all of our public documents that we have on our website and other documents that we've scanned and that we've fed into it. So it's minutes, agendas, annual reports going back to 1850, internal documents, anything that was in a board packet that was anything that was discussed publicly that's been put on the internet somewhere, our internet, I should say. And so I've been able to feed it a whole bunch of different questions. And then, so if I go to research and I give it like the question, like, does anybody have a question that you're itching to know that I can ask it? I've asked it like all the things I've been thinking about. So, all right, history, you know what, I'll just do this. history of wastewater treatment plant. Right. Treatment. Okay. All right. Then we could say summarize the topic, right? And then you, oh, I have to add it in again. Hold on. You can select all the entities that may have had a public discussion or some sort of public document about the wastewater treatment plant for however long, right? Like all the entities. You can set a date range. Sorry, there's a lot of background noise I'm hearing.
I think it might be Stacy. Yep, there we go.
Okay. And then you can select all the different inputs that you want, right? Code, web pages, all these different things. And what it will then give you a thinking summary as it processes this request and all the things that it's looking at, and tell you like what it's doing, and then within a matter of minutes give you a whole a lot of information in a really well formatted format, including citations from which you can print a report. So I've been using it a lot. You can see over here on the left-hand side of the screen the various things I've been researching. And then one of the tools that I know other people in Town Hall have used is the benchmarking tool. And so what this does is this can pull from publicly available information on other municipal websites, right? So you can find out about staffing, staffing for different departments in different across towns, and salaries, and you could just kind of understand like a lot of I wish we had this tool last year when we were trying to figure out, well, what are other towns doing, right? Now we have a tool that really can do it for us and takes away just really quickly, right? So like something that we would have had to go on many different municipal websites and try to find and figure out ourselves, it can now do for us. So that's like the very quick and dirty
Very cool
of this tool. And so what I want to show that to you for is if you think of anything that you're wanting to know about the history of Carlisle, like that you think would be helpful to any of our conversations or just for fun, let me know. I'm happy to ask the tool. It's been great to understand the history of town-owned properties. Like I did a search of like all the affordable housing projects that have been proposed on town-owned land since 1990, came back with like things I'd never even heard of. I thought I knew all of them. So I'm using it towards my, bog house research that I have to submit to the state. So,
can it access GIS data?
It probably could pull from Access GIS. I'm not sure if it does. That's a great question.
So I've actually tried to use, I'm gonna guess no, because I've tried to use it for that. So I'm just gonna guess no, but maybe.
You tried to use Prophecy Gov for that, or just AI?
No, ChatGPT.
ChatGPT, yeah.
Yeah.
Like I wonder if we had if we had the GIS data in the spreadsheet format, I wonder if it could then source those for, I don't know, just a thought.
Yeah, so we can feed it things too. So like as we scan documents and we have all the planning board files scanned, like we can feed it in, so it can pull from those and not just like what's on the internet. And so Ashley, our town clerk, she scanned all of the annual reports back to 1850 and uploaded all that. So it's like also able to pull from that too. So it's just another tool we have at our disposal that can save a lot of time on our end. And then it also cites its sources, so you can verify the information. And it will tell you too if it finds conflicting information or if it doesn't feel super confident about any of the information that it's pulled from. It'll, can give you like a confidence rating.
So I just checked now and it can do it. That's what it's telling me anyway. So the new one can, the old one couldn't.
Cool.
Maybe. I'm pretty sure I asked it before, but it's good. Scary.
Yeah. I don't know how I worked before. I was just thinking of all the questions you guys had during the MBTA communities discussions that I could have just had working in the background while I was like doing something else, you know.
Wouldn't that have been great? Let's not try to relive all of that.
No, I don't want to, but just in terms of bandwidth, it's pretty soon you're not going to need staff, you know.
Oh,
Yeah.
hardly.
Yeah.
Hardly.
Yeah. Somebody's got to interpret all of this stuff.
Critical thinking, critical reasoning.
You still have to ask the right questions.
Yes.
Okay.
All right. Are we ready to call it a night, do you think?
I just realized I have a couple invoices.
Oh,
Oh, yeah.
okay.
Yeah.
Hold on one second. So there were a couple little seminars I signed up for. Let me find them in the let me open them real quick and then I'll screen share them. Okay. So one of them is the MARPA DLS. So that is the Massachusetts Regional Planning Agency and Division of Local Services statewide municipal partnerships conference. It's every year. It's in October. I think it was $20. Yes. It's like half a day. It's basically for regional planning agencies to understand and hear from secretaries of different executive offices and funding and programs and things that we should know about to take advantage of to advance planning efforts. And then the other one that I signed up for is $80 and it's the CHAPA Housing Summit. And so it's tools for increasing housing production in your community. And they have a few different sessions that are like an hour and a half each. And they're in the September and October. So the funding for this would come out of the education and training line of your budget.
All right, I'll take a motion to approve the invoices and authorize the town planner to sign.
So
So
moved.
moved.
I'll second.
Second.
Okay, roll call starting with Chris.
Gigas eye.
Brady, aye.
Lennon, I.
Smith, aye.
Very much. That's all for me.
Hey, well, sometimes we get to have an early night. Motion to
All
adjourn.
right.
So moved.
Second.
Second.
Right, everybody, have a great night.
Good night.
Good night.
Good night.
you.